All right. Good afternoon. Thank you for attending the Council of State Governments webinar for the Dietitian Licensure Compact. My name is Dan Logston. I'm Director of the National Center for Interstate Compacts here at the Council of State Governments. We'll get into who the Council of State Governments is in a second. I'm joined by my colleague, Caitlin Bison. This project is funded through a cooperative agreement with the Department of Defense. The Department of Defense believes that interstate compacts, licensure compacts, are the gold standard for military spouses as they transition from station to station around the country if they're in a licensed profession. States have done a great job of passing legislation to aid military spouses in licensed professions. DOD appreciates that, but they do believe that these licensure compacts are the gold standard. So couldn't be here without their funding. And then also we have with us from the Academy of Nutrition and Dietetics, their president, Lori Wright. So Lori, I'll turn it over to you and thanks for attending today.
Thank you, Dan, and welcome everyone. As Dan said, I'm Lori Wright, president of the Academy of Nutrition and Dietetics. Thank you all for joining us today. Providing nutrition care services in multiple states, either in person or through telehealth, requires a registered dietitian nutritionist to become licensed accordingly in each and every state. This can be very time consuming and costly. A potential solution to facilitate cost-effective interstate practice for licensed dietitians is a licensure compact. The Academy was selected through a competitive grant process for Department of Defense funding to work with the Council of State Governments National Center for Interstate Compacts on an interstate licensure compact for licensed dietitians. Since January 2023, the Council of State Governments has been facilitating the development of dietitian licensure compact in partnership with the Academy. An initial draft of the compact is available for public comment, and CSG is soliciting feedback from stakeholders within the profession before the compact is finalized. We're so happy that you are joining us today to learn about how the compact will work, who can use it, the potential benefits to dietitians, and how to get involved in the public comment period. Now I'd like to introduce you to our next speaker, Matt Schaefer, the Deputy Program Director at the Council of State Government Center of Innovation. Matt?
Hey, Lori, thanks. Matt is under the weather today, so I am filling in for him.
I'm sorry, Dan.
No, it's all right. Thanks, Lori. Appreciate and enjoy working with the Academy on this project. So just a few housekeeping items that I want to go over. So, you know, this is graspable but kind of complex data that we're going to be providing today. We'll do our best to explain it, and I think we do a good job. We've explained all these licensure compacts essentially work the same way, although there's certainly variations on the profession. So I think we do a terrific job of explaining it, but if you want to hold off on your questions until we get to the end, because, you know, there may be slides that will explain what you have a question about. So if you could do that, that would be very helpful. The purpose of this, there are no CEUs for the presentation today for this webinar, and it will be recorded and put on our website. Caitlin will provide that link at the end. So that you can watch it or refer friends to it. There's already one recording up there from the first webinar that we did on the compact. So today's purpose is we're going to give you an overview of CSG, the National Center, very quickly, interstate compacts generally, these licensure compacts. Currently, I think there's 15 existing licensure compacts, and then we'll move into the specifics of the dietitian licensure compact. We'll end up, again, we'll take questions at the end. We'll sort of explain how the process is going to play out. So with that, I'm going to jump into our slides. There we go. All right. So the Council of State Governments, we're a membership organization for states. We're nonpartisan, nonprofit. We were founded in 1933 at the University of Chicago. We ran out of space in 1967. Put out an RFP to the states, and Kentucky gave us the best deal. So that's why someone with my accent is talking with you today. Our our main purpose is that we focus on all three branches of government. So you've got organizations out there that focus on the legislature, focus on the governors. We focus on all three branches and bring them together to, cooperatively address policy issues facing the states. And one of the things that we do that no one else does, although we certainly don't own interstate compacts, are interstate compacts. We founded the National Center for Interstate Compacts in 2004, but again, we've worked on them since our founding in 1933. Virtually every national compact and certainly all these licensure compacts, we had a hand in drafting them and bringing them to fruition. So we're a clearinghouse for the states. We provide technical assistance to the states on issues around compacts. We don't lobby. We're not advocating in any way. We believe these are excellent tools for states to use in certain policy areas. Certainly not every policy area, but what we're known for are interstate compacts, our policy shop, and then the fact that we work with all three branches of government. We've got 4 regional offices that are legislative exchange agencies for the various states divided up by region. And then we've got the CSG Justice Center located in New York, which works with states and local governments on criminal justice issues. And here is a list of all the licensure compacts that are currently either in process or out. Well, all of these are out to the states for consideration. And then we're currently working on dietitian's compact and then a compact for school psychologists. All right, so what is an interstate compact? Interstate compact is a constitutionally authorized tool for states. It's a contract between and among states. Congress sometimes will authorize a compact for states to pursue. Many times they want states to sort of take a first shot at it, and then they'll pass federal legislation. Again, it's not for every policy area. Typically, it's for, in our federal system, it's for things that are reserved to the states. We've got a picture of a driver's license there because, that's an interstate compact that the federal government didn't want to play a hand in people driving from state to state and how that was going to work. So they charged the states with doing that, and the states came up with a driver's license. That's why you don't have to stop at a border and get checked in when you're going from one state to another. There are means for states, again, to cooperatively address common problems. You see them on a by-state basis, a regional basis, and a national basis. They allow states to maintain their sovereignty over federal policy. The federal government are excellent partners, but when Congress drafts legislation, they really can't account for the variations of how states would approach an issue. If the states are around the table, they certainly can. And it does allow the states on certain issues to come together and speak with one voice. These licensure compacts, they started with the nursing compact back in the early 2000s. It got up to 25 states, kind of got stuck there. There were some issues around discipline. There were some issues around the Interstate Commission. We'll talk about the Interstate Commission a lot today. And they rewrote it, went back out to the states. Now they're over 40 states. They resolved those issues. And then you saw numerous professions come in after that. Again, they all work a little bit differently. States have responded well to these licensure compacts. As you see there, over 289 separate pieces of legislation around licensure compacts have been enacted, and 15 professions are in them. So, these are policies that the states believe in. Again, they're not for every profession. Certainly a profession has to be licensed. That's the main requirement. But again, even if a profession is licensed, it would depend on its size. It would also depend on, what sort of area that it's in. My father, for some reason, has an auctioneer's license, and no offense to auctioneers, but they don't need an interstate compact. If you're in a health or allied health profession, we feel that, it's certainly a viable candidate for a compact. All right. And then here's a list of the compacts, again, and the number of states that they have. So you see, nursing compact, the medical compact for physicians there at 41. SciPact actually is up to 41 now as well. So we got 3 states into the low 40s. And then we've primarily facilitated over the last couple of years audiology, speech language pathology, counseling, and OT, and you see where they are. All right. And so the benefits generally for practitioners is it saves them time. It saves them a lot of time, but it also can save them money when they're practicing in multiple states. And that's what these things are really designed to address. It allows them to leverage technology, certainly telehealth, and certainly since the pandemic has exploded. And all these licensure compacts have means to support military spouses, which is why the DoD believes in them so much. For licensing boards, so these are the one area of public policy, and there's only a few, where the regulator doesn't get left behind. One of the things that the compact does is it creates a structure for the regulation of a profession in a multi-state setting. It still relies on those states having the ability to deal with issues around scope and discipline in their state, but it's really coordinated and over multiple states that are members of the compact. Compact data system plays a key role in that. And, the only reason you license a profession is to protect the public. And again, this is an instance where we don't leave the regulators behind. And then for states, there are a number of benefits. Again, no one wants to see the federal government involved in occupational licensing. We've seen a couple of examples recently where they dipped a toe in it and it's causing a lot of problems. It strengthens state sovereignty, which is, again, one of the main reasons that interstate compacts exist. These are very powerful tools for states. They're not to be used for any sort of policy area. They're not to be used lightly. They take a long time to create and get stood up. It's a state has to go through a process to leave them. So they're binding on states and they're very powerful. But it does enhance cooperation among the states. It also strengthens the state's labor market. It increases access to qualified practitioners, which, with Hope Licensures has accomplished that in the various states. All right. So the way that we create an interstate compact is it's a long process. For these licensure compacts. We've been able to streamline it because, again, they're all kind of the same, but you can't pull down the OT compact or the counseling compact and everywhere it says counselors or occupational therapists, insert, a dietitian. So, it doesn't work like that. The first thing we do is convene a larger group. It's called a technical assistance group. They really sort of scope out the issues, set parameters, identify policy areas that they think the compact should cover, make suggestions around that. And then the real work happens with the document team. That's a much smaller group that is convened with our legal counsel. We do bring in agency attorneys as well, or executive directors. We get great feedback from them, and we will develop the actual wording of the compact. And then we go out for stakeholder review, which is where we are now. We run an open, transparent process. We'll take feedback from anyone. We'll get to that later as we go through the presentation. But I would encourage all of you to fill out the survey that we're going to direct you to about the compact. Again, we'll look at all of it. The document team will look at every bit of it and evaluate it. It's not a vote. We're not going to take the most popular provision, but because we have to base these on policy and the statutes in the various states. But again, we want your feedback, and we've already gotten some terrific feedback that the document team will likely have to tweak the draft document around. All right, so that is about the process and give you a brief overview of interstate compacts. So now we want to get into an overview of the legislation. So we'll talk about the compact model. So there's essentially there's four. There's essentially four models for these interstate occupational licensure compacts. So I mentioned the nursing compact. The nursing compact relies on a multi-state license. So you get a multi-state license in one member state, that's your home state, your state of primary residence, and you can work in any of the other compact member states. Works just like your driver's license in many ways. When the physicians were creating their compact, that was really the only example they had. They didn't think the states would embrace that. Certainly medical boards were skeptical of that approach. So what they have is expedited licensure. So it's sort of like TSA PreCheck. There's a streamlined process for you to get access and authorized to work in other states, but it depends on actually getting a license in those states. It's a very expensive model. It costs a physician $700 to engage with the medical licensure compact. You have to, again, pay the licensure fee in all those states. You have to keep up with the CE in all those states. But again, if you're a physician and you're practicing in multiple states, it is preferable to go into each state and getting licensed. The other model let me cover the teaching compact. So the teaching compact is different from all those. It's essentially a licensure exchange model, although you don't have to give up the license you're exchanging. States view teachers differently. They're very protective of their licensure process with teachers. So, that was something that profession required that I don't think would be applicable to any other profession. The vast majority of other compacts use what is called a compact privilege model. The first one was the physical therapist, and I wonder if the physicians had come along after PT was done, if they would have chosen this model. So what it does is relies on a compact privilege. So you're not getting licensed in another state, you're just getting a compact privilege there, and it's based on the requirements in the compact. And the main requirement it's based on is that you have a clean and unencumbered home state license in a compact member state. So we'll get into the home state license more in a few minutes. We rely on the home state license with many of these compacts, but a couple we don't, and I'll explain that as we move through. But for this compact, we felt it was important to use the home state, just like, again, the vast majority of all the compacts, except save a couple, use that. So you hold an active unencumbered license in a compact member state, a home state license. You decide that you want a compact privilege, you apply for a compact privilege. All these licensure compacts, save the cosmetology compact, require an FBI fingerprint-based criminal background check. It's something that's standard. It's something that legislators expect to see. States that already require an FBI fingerprint-based background check will not join a compact that doesn't have that requirement. It really gets down to a trust issue. All these licensure compacts really rely on trust. You're trusting that other state boards do an effective job just like you do. You submit that information for a background check. If that state doesn't see anything there that gives them any pause, if you are eligible based on the other criteria in the compact, having a clean license, completing a jurisprudence exam in the state you want to go to, then that makes you eligible for an interstate compact privilege. You get put on the good list at the compact commission, and then you can go there and purchase a compact privilege for the states that you want to work in. This jurisprudence requirement is, again, that's something that's kind of standard. If a state has one, you have to take that. They're typically open book. The state just wants to get you on the record of saying, I know the Practice Act there, I know what's required, so that if you were to violate the Practice Act and they brought you in, you really couldn't say, oh, I didn't know that, or I didn't understand that nuance. Like, well, you said you took the jurisprudence exam and you should have known it. So this compact privilege model also protects the state board's revenue. State boards rely in many states, they don't get general funding. PT came up with this model, the Federation of State Boards of Physical Therapy, in order to protect the revenue for their state boards. The nursing compact, the PT compact will tell you that the financial impact to boards is de minimis. But again, with the PT boards, they're not nearly as flush with cash as the nursing board. So they had some real concerns. And again, the vast majority of the current licensure compacts follow the compact privilege model. All right, so here's a summary. We're going to spend a lot of time on sections 3 and 4. We'll talk some section 5 and 7. 6 is a military spouse requirement that all these licensure compacts have. And then from section 8 to section 14, this is the boilerplate. This is in all the licensure compacts that we create. It looks the same compact to compact. We actually just spent 6 months tweaking it last year. It governs the administration of the compact by the Compact Commission. Now, when we talk about the Compact Commission, we're not talking about CDR. The Compact Commission is an instrumentality of the states. It's actually a government agency that is formed when the compact is enacted in the member states that trigger the creation of the compact. So, it's populated by state regulatory board personnel or board members. And again, it's there to implement and administer the compact, and that's it. It's not some sort of super regulatory agency. All modern compacts rely on a compact commission, whether licensure compacts or not. States have found, and CSG has found over the years, that that's the most effective way to administer these compacts. So, we have to have that. But again, want to make sure there's no confusion here when we say commission, because I know that's something that the profession, you also call the CDR, the commission. We groped for some ways to try to refer to it in a different way, and nothing really worked. So excuse us for the confusion that may cause. All right, so section 3. So section 1 is the purpose. Section 2 is the definition. Section 2 is probably the most important part of the compact. And then you've got section 3. So this is a section that tells states how they can join the compact. So in terms of this compact, I'll get into home state here, and I'll mention it again in section 4. So in order for a state to join this compact, they have to license and regulate the practice of dietetics and nutrition. So, unfortunately, there's a few states that wouldn't be able to join this compact, unless they can get licensure enacted in their states. That's California, Colorado, Virginia, Michigan, and Arizona. But all the other states, by our account and our research, are eligible. And again, this section describes what a state has to do to join. So they have to license and regulate the practice of dietetics and nutrition. They have to require licensees to pass a nationally recognized exam. We leave that language flexible. We don't specify exams. We never specify exams in the language. And that's intentional. There's flexibility built into these things for a reason. We want these compacts to last a long time and to operate a long time. We want them to be evergreen. We can't write them so broadly that states are scared about what a compact commission could do to implement them, because you have to give them direction. But if you write them too narrowly, you're putting them in peril right away. So we do leave strategic elements broad for the compact commission to operate. There's nothing to say that national exam is going to go away. But if it ever did, or it renamed itself, that could cause significant problems with the compact. So we leave that broad so that the compact commission, if it ever deems it to be necessary, could define what that national exam is, or could state what that national exam is. It has to implement the procedures around an FBI fingerprint-based criminal background check. I kind of touched on that earlier. That is something that legislators don't see that as a burden to practitioners. They think it is crucial for interstate practice. And they also think, given the benefits that the compact provides to practitioners, again, it's not too much to ask. And then, states have to have continuing professional development required as a condition of renewal. We've gotten feedback about this. We're aware that some states, don't require continuing ed, but instead require maintaining the RD credential. So, these CE requirements, this provision in the compact is something that, this is why we do stakeholder review. We've gotten comments about, we've gotten questions about, and so the project team and the document team will revisit that when we reconvene to go through all the stakeholder review comments and the feedback. So, this is the benefit of putting this thing out for comment, is that, we get checked on our work. And so, that is an area we're going to have to revisit as we move through the process. All right. And so section 4, this is where we lay out the requirements for a practitioner. When we get into discussion about this home state, you have to have a valid unencumbered home state license to participate in the compact. The reason we rely on the home state is, compacts thrive on uniformity. So if you've got a profession that the licensure requirements are different in every state, they really can't enter into a compact together, because there'll be no trust. We do it differently. We do it very differently from the way you differently. I don't want your practitioners in my state, and very likely you don't want mine in yours. Relying on, that home state clears up a lot of those issues. There's uniformity with this profession in how they're licensed, or, we couldn't create a compact, but there is a little bit of variability. And in order to give states that sort of comfort that we're not seeing a run on a state that is deemed to have lower requirements, we don't have venue shopping as far as licensure. The home state requirement there is crucial. So just want to mention that at the top, and I'll probably mention it a couple more times, because it's something that we really want to drive home. We know practitioners would, like to have the flexibility of being licensed in any compact member state. And, we certainly hear you on that, but for various reasons, it's with this profession, it just didn't make sense. Most of the compacts that exist rely on that home state provision. So this compact has 2 pathways. So, if you're have a valid and current RDN registration, you're good to go. You can participate in the compact, given that you complete some of the requirements here below. Or a master's degree or doctoral degree that is programmatically accredited by ACE&D, 1,000 hours of accredited supervision, and then successful completion of the registration examination there for dietitians administered by the Commission on Dietetic Registration. This mirrors what the licensure requirements are out in the states. Again, that's our uniformity, and that's where we went. Relying solely on the RDN credential, because some of you may be sitting there thinking, well, why didn't you just rely on the RDN credential? We wanted to put it here because, again, states do rely on it, but we wanted to give an alternative pathway, one, because states do, and two, you could get into some antitrust issues. You could get accused of some antitrust behavior with the compact if you don't sort of take those precautions. So that's why we provide a second pathway. So again, if you've got a valid current RDN registration, you can participate in the compact, but we're not requiring you to, but I think vast majority of practitioners do. Let's go on to the next slide. Okay, you have to hold an unencumbered license in the home state. Again, I'm going to come back to the home state. It's something that, again, I know practitioners, if they had their preference, they'd probably just choose, like, we can get licensed in any state and participate. That being said, legislators do like to see the home state. If there's not almost total unanimity among the states on licensure, there's two compacts that don't require the home state, and it's the dental compact, and that's the compact for physicians associates or physicians assistants. But there's no variance among the states on how they're licensed. There's a little bit of scope variance, but there's no variance on how they're licensed in the state. So that's why they can do that. There's not this concern about people going to state with what might be considered lower standards to get licensed. So, and again, these compacts rely on trust. You're asking the state boards to trust that other states are doing this just as well as you're doing it. So in this instance, the home state is something that we're going to have to rely on. And I promise I'll try not to mention home state again. You can't have any encumbrances or restrictions on the license for the previous 2 years. We think that look back is appropriate. Other compacts use that. You have to pay the applicable fees for the compact commission and the remote state. So there's two fees that'll be associated with the compact. You'll have to pay the commissioner fee, and you'll have to pay the home state, the remote state fee, the state you want to practice in. I wish I could tell you how much those are going to be, but I can't. The PT compact charges $45 at the commission level, and it encourages its member states to charge $45. Some do, some don't. Some set that fee $50 to $75 below what a license renewal fee is. But again, it's important to also remind yourselves that, in addition to, a savings on licensure fees, you're also going to have a huge time savings. You're not going to have to dig up, any sort of records from your education. You're not going to have to provide copies of where you're licensed. I get a little put out sometimes when the state tells me, it's like, well, we don't need a compact. We can license people in a day. It's like, yes, you can, after they've spent 2 months compiling all the data. So, that's really not applicable here. With the compact privilege, you go from, it taking weeks for states to issue a license. And look, state regulatory boards are understaffed. They're underfunded in many states. So, they do the best they can, but typically it takes weeks to get a license. With the compact privilege, you could get that in a matter of days or even hours. You're getting a tremendous benefit there as a practitioner. And then again, I mentioned this earlier, meet the jurisprudence requirements. States just want to get you on the record as saying you read their Practice Act and you understand it, in case you ever come before them and try to argue that that wasn't clear to you. Okay, there's some other great benefits in the compact. Section 5 here, I said we talk about it. This is the ability for practitioners that are participating in the compact to have a streamlined process to get a new home state license. So let's say that your practitioner, will use Kentucky as an example, in Tennessee. Your home state is Kentucky. That's where you have your license at your primary state of residence. You got a compact privilege for Tennessee. If you were to move to Tennessee or any other compact member state, there'll be a streamlined process for you to get a new home state license in that state. And the rationale behind that is you could practice full-time in a member state with that compact privilege. And so it doesn't really make a lot of sense that, just because you change your primary state of residence and it's a compact member state, that you would have to go back through the entire licensing process in that state. The counseling compact was the first compact to do this, and then the OT compact wanted this provision, and it's something that other compacts are now relying on. Because again, especially with these privilege models or even a multi-state model, if you're, you can practice in another member state full-time on that multi-state license or the compact privilege. So, why shouldn't there be a streamlined process if you change your primary state of residence to get licensed there without having to go through the entire licensure process again and do the primary source verification? Section 6 is for active duty military and their spouses. They can designate a home state that they can keep throughout their time of service. And then they can, relocate there or to another compact member state once that service is finished. Adverse action. So we've got a slide that touches on this a little later, along with obtaining a new home state license. Again, this is one area of public policy, and this is one mechanism that states utilize where we don't leave the regulators behind. The only reason you license a profession, as a friend of mine likes to say, is so that you can take it away from someone if they aren't practicing in an appropriate manner and not adhering to state laws. And so what the compact does is it allows states to exchange information. It allows them to jointly come together and mete out discipline and handle adverse actions in a multi-state regime that the compact creates. So again, section 8, 9, 10, 11, 12, 13, 14 deal with the administration of the compact. The compact will establish an interstate commission. Again, that commission is not CDR. It's an instrumentality of the states. It's a government agency, and it's what the states will use to administer and implement the compact. That's all it can do. It can't take unilateral action against the practitioner. It can't dictate policy to the states. It can't, again, infringe on a state's scope of practice. That's outside the power of the compact. The data system, that's the primary mechanism that states will utilize to make each other aware of practitioner adverse actions and to help track disciplinary issues. It's also what will back up a practitioner's ability to get compact privilege. All right, and then the rest of the compact, as I mentioned, is exclusively dealing with administration of the compact. We got some slides coming up about that. All right, so I covered this pretty extensively before, but here's a visual representation of it. Again, it just doesn't make any sense if you can practice in a state full-time other than your home state with a compact privilege, that when you move to that state, if you were to move to that state or any other compact member state, that you would have to go through the primary source verification process and do all that. So again, you've seen this in more and more compacts. It's something that states are getting used to. With the counseling compacts, it was the boards that actually asked for this provision. With OT, we put it in, we took it out for stakeholder review. I thought the boards would push back. They didn't. So this is something that regulators will accept readily, and we don't think it'll be an issue with this compact. And again, this is another benefit for practitioners. As for adverse action, so getting back, okay, I am going to mention the home state license one more time, but this would be true for other compacts, dental and PA that rely on a state of primary licensure. The license that punches your ticket to get in the compact, in this instance, if your home state license, if that ever becomes encumbered, you lose all your compact privileges. And the reason for that is that home state license is the means, that unencumbered home state license is the means for you to actually participate in the compact. So if it goes away, your compact privileges go away. This is how they all work that rely on home state. You can certainly, rectify issues with your home state license. And after that 2-year look back period, if the board deems that you're eligible to have your license restored, you could get back and participate in the compact. But again, that home state license is the key for you to get into the compact. And again, all this information is shared via the compact data system. If you lose a privilege in a remote state, that doesn't automatically trigger that you're going to lose your privileges in other states. They'll see all that information. They could potentially launch an investigation of their own, especially your home state could. But it's not an automatic process. And the reason for that is And again, it is for PT, it is for nursing. If you violate Practice Act in one member state, you lose your multi-state license. State policy has moved away from those sort of, very punishing provisions. And also, when we were writing the speech pathology and audiology compact, we had a board administrator on the team from Oregon. And, she explained that, anything around cannabis, her state board wouldn't take action on. And that got us thinking about, well, there's other issues that states, and some certain states wouldn't take action against and some would. It gets back to that whole state sovereignty issue. And so therefore, if you lose a compact privilege in a state, that doesn't mean necessarily you're going to lose the compact privileges in all the remote states, or that your home state will take any action. And again, this is the reason we have the compact data system, is so states can be aware of all that information. All right, and then section 10, 11, 12, 13, 14, you see there, rulemaking. Compact will create rules, oversight, dispute resolution, and enforcement. Another reason to have a compact commission is to enforce the provisions of the compact. If a compact doesn't enforce its provisions, at some point, states will be operating outside the compact, and like what happened with the multi-state tax compact, the federal judge is going to say it's not a compact anymore. So it's crucial for states to enforce the provisions of the compact. With these licensure compacts, you really don't see that often, but it's best practice for us to include this language. The effective date withdrawal and amendment, again, that's just something that helps the states with onboard new member states, and then how they can amend the compact if they should ever decide to do that. Construction and severability deals with constitutional issues. Compacts, the binding effect of compacts and other law. So I mentioned earlier that these are very powerful tools for states. Compacts supersede conflicting state law. If there's a provision in the compact and it conflicts with a state law, the compact supersedes it. Now, that's not a concern for most states. As I pointed out earlier, 289 of these licensure compact pieces of licensure compact legislation has been enacted in the states. These deal with very narrow policy areas. Again, the compact doesn't interfere with scope, so there's not going to be issues there. How states license within their state, as long as they don't touch the eligibility requirements for the compact, there's not going to be any conflict there. So again, states are comfortable with that. But for other compacts and other policy areas, this is a very important provision. Again, it gets back to enforceability. Compacts don't supersede state constitution. So there are a couple of states, Oregon, Montana, that have provisions in their compact that would require us to tweak the compact language to be enacted in that state. And the reason we can do that is because of this construction and severability clause. All right, so want to say one more thing about the compact commission that's represented on this slide. Again, I'm not talking about CDR. It's a government agency. It allows for the effective implementation of the compact, and then it allows for the compact to be administered. It can't take action against the practitioner. It can't take unilateral action. It can dictate policy to the states. It's not some sort of super regulatory agency. It's just there to implement and administer the compact. Legislators sometimes have a lot of concern about the compact commission and its rulemaking authority. Rules of the compact are considered statutes in the compact member states. But again, the compact is hemmed in by the boundaries of the compact. It can't get outside that original language or the intent of that original language. We thought it was important to include a provision like this. So, this is a very important provision for the compact, and the project team and the document team felt like it was important. So I'll let you read that there. But that was in the hope that to give some states some comfort around their ability to license and regulate the profession. All right, so we developed this draft over the summer and went out for stakeholder review at the end of July. So we're currently soliciting public comment. I think Caitlin's going to put the link to the survey and the document in the chat. We want to have this finalized in either late September or early October. That'll give the profession plenty of time to get ready for state legislative sessions. It takes as long as it takes. If it takes us until the end of October, which we don't expect, we'll have to take those times. It's more important to get it right than it is to get it done quickly, but we've moved at a brisk pace. We've got a terrific project team. So again, we expect, on our experience, we expect to get this done by the end of September. There are resources available at the website. There's a terrific one-pager. There's some FAQs. We'll update those as we move through the process. Again, want to say about stakeholder review, we welcome your comments. We want your comments, but it's not a vote. We're not going to make changes just because, a lot of people wanted certain changes. We'll vet this again as a document team. We'll vet it again as a project team. If it makes sense, if it aligns with the mission and the purpose of the compact, we're going to consider those. I mentioned the CE topic earlier, but again, just want to have everyone understand that this isn't a vote, but we do want your feedback. We always get terrific feedback during this process, which is one of the reasons we do it. We also do it because we run open and transparent processes. So I think that is all that we have. So Caitlin, did we get and there's my email address and Matt's, who couldn't be here today. If you have any questions about the compact or have any comments or having trouble accessing the survey or the document, you can reach out to us. And I'm going to stop sharing. And Caitlin will take questions now. And I hope we didn't go too fast. We've got 17 minutes for questions, so Caitlin's gonna provide those, and I'll do my best to answer them. And if I don't have an answer, we'll put it in the FAQ and post it later.
One question we got would be, can I join the compact if my home state does not have licensure for dietitians?
No. Now I saw something in the chat about certification. So there are some states in other professions that have a certification process, and it's really licensure by another name. For speech pathology and audiology, Colorado doesn't issue a license, it issues a certification, but that process and the effect of that process is licensure. So they were eligible to join. So if that's the case with a state for this compact, certainly we would deem they're eligible to join. But if your state doesn't license or have a certification process that looks like licensure, then unfortunately, unless licensure is enacted in that state, you wouldn't be able to join the compact.
Okay, another is asking what you mean by home state, and do they have to be licensed in their home state in order to join the compact?
All right. So the commission can define this we're working on a lot of compacts right now. Caitlin, do we define primary state of residence in definitions? Okay, we are great. So again, there's a definition in the compact around primary state of residence. Your home state is essentially where you vote, or the primary state where that's the address that's on your tax forms. Your federal income tax would be another way that some of the compacts define it. So that's your home state. I would encourage you to look at the definition in a compact, but I always use those two examples. The address that you use on your federal income tax and then where you vote is typically your primary state of residence. The compact commission may feel the need to flesh that definition out a little bit, provide more clarity, but those are the examples that I've seen in other compacts.
Could you address states that are eligible to join the compact that have licensure versus certification?
Yeah, again, if a certification process in a state is essentially, like I said, licensure by another name, if it acts like licensure, if it resembles licensure, if it has the same functions as licensure, then we would consider that license and your state would be able to participate. But again, if these licensure compacts are obviously based on licensure, I get back to the whole trust issue. states that require licensure and regulate the profession based on that license, don't want to be in a compact with a state that doesn't do that, obviously, because they don't want those practitioners coming to their states. That's not specific to this profession. That's for any profession. And so, again, it would depend on what that process looked like. But if it was essentially licensure by another name, then CSG would deem that state eligible to join the compact, but we'll have to take those on a case-by-case basis.
We had a question about the compact privilege fees, if it's a one-time fee or would you have to pay for each compact privilege?
Nope, that's a great question. Sorry, I didn't cover that in a better way. So the compact privilege will renew at the same time that your home state license renews. So yes, you'll have to pay, like you have to pay a renewal fee for your home state license, you'll have to pay a renewal fee for the compact privilege. That will operate the same way. It's like that for all the compacts that utilize a compact privilege. So it's not a one-time fee. It is a fee that you would have to pay based on the renewal cycle of your home state license.
Another question was about how long it usually takes to get a compact privilege.
Yeah. So PT can issue a compact privilege in 10 minutes. They've been operating for about 5 years now. So they've made enhancements to that compact data system that allows them to do that. Again, state boards typically take weeks, and that's not, necessarily their fault. They have a process that they have to adhere to in statute, and state regulatory boards are typically underfunded and understaffed. But with the compact privilege, I think at most for new compacts, it would be maybe a couple of days, maybe just a few hours. It'll probably take a while to get down to minutes, but that is certainly the goal for all these privilege compacts.
Another question was, how is this different from state reciprocity or universal recognition laws?
Yeah, that's a great question. So, compacts thrive on uniformity. They also offer the states uniformity. With these universal licensure laws, which our member states enact, so we're not going to be negative about them, but they all operate a little bit differently. I mentioned that DOD thinks that compacts are the gold standard for military spouses, and the reason for that is the requirements are the same in every state. There's uniform application throughout the states. Every state has taken time and put a lot of consideration into passing bills to help military spouses in licensed professions. But again, they're all different. And if you're a military spouse, you'd have to keep up with that. They also would require that, and I didn't mention this either, and I apologize, that a military spouse, probably hang on to that license, unlike the way the compact structure would just, designate a home state license, but they would also have to complete the continuing education in that state. And another big benefit of the compact is you're only required to keep up with the CEs around your home state license. So that's another huge benefit for the practitioner. CEs are not attached to the compact privilege. So if you get an authorization to work in a state, you can work in that state. Again, you have to keep your home state license clean and unencumbered. And obviously that means completing the CE there, but you wouldn't have to complete the CE based on that compact privilege. So ULR laws, again, they work for some professions. I think when it comes to a compact versus ULR law, the compact's superior just because of the uniformity it applies across the states. Also, ULR laws are good for people that want to come into a state. If you're a practitioner in that state, you really don't get any benefit from it unless all the other states pass one. And again, they're not uniform. So that's the biggest difference. What is a ULR law? That's what we call them. We thrive on acronyms here. Those are universal recognition laws. So about 17 states have passed these laws. And again, they all operate differently. If you bring a clean, valid, unencumbered license to a state, they'll issue a license to you from that state. They're not that simple. Well, a couple states are that simple, but most of them, aren't that simple. Arizona requires that, you take up residence in that state actually for its universal recognition law.
I believe this was mentioned earlier, but just to be more specific about it, we had a question about military spouses and the requirement for home state. Is that a requirement for them to be licensed in their home state?
Yes, but they get to designate that state. So let's say that their home state is Kentucky, their spouse is stationed in Kentucky, they're a licensed professional in that state. They then get deployed to their spouse gets deployed to another state, have a change of station, regardless of if that state's a compact state or not. They can stay in the compact. They can say, well, okay, I'm going to designate Kentucky as my home state. Yes, I now live in Nebraska because, my spouse practices or excuse me, is deployed here, but they can stay in the compact based on their designation of Kentucky as the home state. That's the biggest benefit for them.
Okay, and we have kind of a two-part question. First, people were wondering about what states are not eligible to join the compact and how they join the compact, or the process through which they do so.
Sure. So the states that I have that aren't eligible are California, Colorado, Virginia, Michigan, and Arizona. And in order to be able to participate in the compact, those states would have to license the profession, and they would have to meet the requirements in the compact. So you see this in other professions, not typically, licensure, but I know with speech pathology and audiology, there were 3 states that didn't require a clinical practicum. So they were ineligible to join. I believe all 3 of those states have now passed that clinical practicum piece, excuse me. For counseling, it requires a 60-hour master's degree that states must currently license at a 60-hour master's degree level. So if you're a practitioner who got licensed 10 years ago under a 48-hour requirement, that's okay. You're essentially legacied into the compact. But you've also seen with the counseling compact, then there's only a handful that did that, that didn't have 60 hours. You've seen them start the process to move to 60 hours. So, this isn't some sort of new invention here for this compact. There's, again, there's uniformity for this profession, but there are a few variances. And, certainly in other professions that have the same situation, you've seen the states that want to join the compact remedy that.
Okay. Another question would be, is there kind of a maximum number of states you can join through this compact? And when will it start becoming available to states to join?
Great question. So you can get as many compact privileges as you like, as long as you have an unencumbered home state license in a compact member state. Timing, that's always hard to predict. Caitlin, have we set the activation number yet? Is it 7?
Yes.
Okay. So this compact requires 7 states in order to begin operations. There's a good chance that we've seen other professions do this, get 7 states their first year out in the legislative sessions. Typically, when it's 10, it takes them 2 legislative sessions to do that, but we have seen states get 7 in a single legislative session. And because we're going to finish at the end of September or early October, there's plenty of lead time to get ready for the next round of legislative sessions in 2024. So this compact could potentially meet that threshold number of 7 to begin operations at next summer. It typically takes 12 to 14 months for the commission to get up and operating. The data system, building that data system, getting it operational is certainly always a consideration. It may take a little bit longer, but again, these things are expensive and they take a long time to get up and going, but they are built to last. Decades is their projected lifespan. So, probably if we can reach that threshold number next round of legislative sessions, you're looking at, 14 or 12 to 14 to 16 months before it could be operational after that. So I wish it was sooner, but these things do a lot. They, extend the state's ability to protect the public. They give tremendous benefits to practitioners for multi-state practice, and they protect state sovereignty. So there are a lot of moving parts there.
Okay, and as kind of a good wrap-up question, we had somebody ask how they can get involved and stay updated on this process as it happens.
So, once we finish the compact, so you can check our website for updates that I think, Caitlin, we can put that in the chat again. So it's at the top or bottom. I never know. But also the Academy. So once we finish this, you can certainly look for updates and look to the Academy for advocacy efforts. Again, I mentioned the resources that are currently available, the one pager and the frequently asked questions. One of the things that we also provide through this Department of Defense cooperative agreement is, there'll be a project website for the for the compact, and that will also contain a legislative resource kit. So if you are interested in advocating for the compact in your state, we don't do advocacy, we do technical assistance. You can reach out to the Academy and find out how to get involved. And you can also just take that legislative resource kit and work with, your state association or, a group of friends that are also dietitians or a state legislator, and work to get the compact enacted in your state. So someone asked here, what was something about if the state joins the compact, does that open up your licensure laws to the compact commission? Or no, the compact can't dictate how you license a profession. You have to stay in compliance with the compact, but it doesn't dictate. But like I said, like I pointed out, vast majority of states are already eligible to join the compact. But no, it doesn't dictate licensure requirements to states, and it doesn't dictate scope of practice to states. It can't do that. All right. Well, thank you everyone for joining. I hope you got a lot out of it. If you need us, please contact us at those email addresses, check the website. And then once we finish, we'll have a project website you can access through CSG or the Academy. And it was great talking with you all today. Thanks.